Mr. President, the United States is in the final stages of negotiating the Trans-Pacific Partnership, a massive free trade agreement with Mexico, Canada, Japan, Singapore, and 7 other countries. And I come to the floor today to ask a fundamental question. Who will benefit from the TPP? American workers, consumers, small businesses, taxpayers, or the biggest multinational corporations in the world? One strong hit is buried down in the fine print of the closely guarded draft. The provision, an increasingly common feature of international trade agreements, is called Investor Dispute Settlement, or ISDS. Now, the name may sound mild, but this provision fundamentally tilts the playing field further in favor of big multinational corporations. Worse yet, it undermines U.S. sovereignty. ISDS allows foreign companies to challenge American laws and potentially pick up huge payouts from taxpayers without ever stepping foot in an American court. Now, here's how it works. Imagine that the United States bans a toxic chemical that is often added to gasoline. We ban it because we believe it is dangerous for people's health or harmful to the environment. If a foreign company that makes this toxic chemical wants to sell it in the U.S., it would normally have to challenge that in the U.S. court. But with ISDS, the company could skip the U.S. court and go before an international panel of arbitrators. If the company wins, the ruling cannot be challenged in U.S. courts, and the arbitration panel could require the American taxpayers to cough up millions, even billions of dollars in damages. ISDS has the power to impose gigantic fines, but it doesn't have independent judges. Instead, highly paid corporate lawyers go back and forth between representing corporations one day and sitting in judgment of corporations the next. Now, I don't know, maybe that makes sense in an arbitration between 2 corporations, but not in cases between corporations and governments. We should have real doubts about how likely it is that a lawyer looking to attract high-paying corporate clients will rule against those corporations when it's his or her turn to sit in the judge's seat. It's also a real problem that the only international investors get to use these courts. Investors that are, by and large corporations. If a Vietnamese company with American operations wants to challenge an increase in the U.S. minimum wage, it can use ISDS. But if an American labor union believes the Vietnamese companies are paying slave labor wages in violation of trade commitments, the union has to try to wind itself through the Vietnamese courts. Good luck with that. These rigged pseudo-courts were created after World War II because investors worried about putting money into developing countries where the legal systems were just not as dependable. They were concerned that a corporation might build a plant today only to watch a dictator confiscate it tomorrow. ISDS was born to encourage foreign investment in countries with weak legal systems. Now, look, I don't know if these justifications made sense back then, but they sure don't make sense now. Countries in the TPP are hardly emerging economies with weak legal systems. Australia and Japan have well-developed, well-respected legal systems, and multinational corporations navigate those legal systems every single day. But ISDS would preempt their courts too. And to the extent there are countries that are riskier politically, market competition can solve that problem. Countries that respect property rights and the rule of law, like the United States, should be more competitive. And if a company wants to invest in a country with a weak legal system, then it should buy political risk insurance, which is available. The use of ISDS is on the rise. From 1959 to 2002, there were fewer than 100 ISDS claims worldwide. But by 2012 alone, there were 58 cases. That's in 1 year. Here are some examples of recent cases under various treaties with ISDS provisions. A French company sued Egypt because Egypt raised its minimum wage. A Swedish company sued Germany because Germany decided to phase out nuclear power after the Fukushima disaster. A Dutch company sued the Czech Republic because the Czech Republic didn't bail out a bank that the Dutch company partially owned. And American corporations are getting in on the action too. Philip Morris is trying to use ISDS to stop Uruguay from implementing new tobacco regulations aimed at cutting domestic smoking rates. Now, ISDS advocates point out that, hey, so far this process hasn't hurt the United States. And our negotiators, who refuse to make the text of this trade agreement public, claim that it will include a bigger, better version of ISDS that will protect our ability to regulate in the public interest. But with ISDS cases exploding in the last several years and more multinational corporations headquartered abroad, it is only a matter of time before such a challenge does serious damage here. Letting a panel of arbitrators replace the U.S. legal system with a complex and unnecessary alternative on the assumption that nothing could possibly go wrong seems like a really bad idea. This isn't a partisan issue. Now, I don't often agree with the conservative Cato Institute, and I suspect they don't often agree with me. But this morning, the head of Cato's trade policy program said that ISDS, and I quote, raises serious questions about democratic accountability, sovereignty, checks and balances, and the separation of power. They went on to say, these concerns about ISDS are, quote, ones that libertarians and other free market advocates should share. I think that's right. Conservatives who believe in American sovereignty are outraged that ISDS shifts power from American courts as envisioned by our Constitution to unaccountable international tribunals. Libertarians are offended that ISDS effectively offers a free taxpayer subsidy to countries with weaker legal systems. And progressives should oppose ISDS because it allows big multinationals to weaken labor and environmental rules. Giving foreign corporations special rights to challenge our laws outside of our legal system is a bad deal. So long as TPP includes investor-state dispute settlement, the only winners will be international corporations.